Hello everyone. Today I'm going to talk about a very important topic which is called as the Places of Worship Act. Okay, so this is a very controversial act in the recent past, and this Places of Worship Act is such controversial act primarily because this act of 1991, it was passed by the Indian Parliament when a movement called Ram Janmabhoomi movement was at its peak in 1991. So this movement was being led by none other than Lal Krishna Advani. So and this Ram Janmabhoomi, when it was at its peak, there was a dispute between the Ram Janmabhoomi or the Ram Mandir and Babri Masjid. And when it was at its peak, this act was passed. And the Places of Worship Act, what it tries to do is, first and foremost, it tries to, or it in fact bans the conversion of religious character of any place of worship. The very first provision of this act is what? There cannot be any change in the religious character of any place of worship. And second dimension is the religious character of a place of worship is feasted as it is present on 15th August of 1947. They have put a cutoff date, that is 15th August of 1947 is the cutoff date, and whatever religious character is present on the 15th August of 1947, the same religious character is going to continue, which effectively frees the religious character of all the places of worship across the country as is present on the day of Indian independence. So this was the central provision of the Places of Worship Act of 1991, and this act was passed in order to maintain the communal harmony of India. Because there have been many claims at one point of time, particularly during the Ram Janmabhoomi movement, that during the medieval era in India, according to the Hindu right wing, even though there are no objective evidences for it, there is a claim that nearly 40,000 temples have been destroyed in India and mosques have been constructed over them, even though there is no objective basis for this 40,000 temple thesis. But even then, the Hindu right wing, particularly it was trying to provoke many other disputes in places of worship, because they say that the Muslim places of worship have been constructed on the places where an earlier Hindu temple was present. So because of this reason, in order to maintain the communal harmony within the country, so what these people have done is they have passed the act called Places of Worship Act in 1991, and very uniquely, this act, so in fact, it upholds a principle which is called as non-retrogression. Non-retrogression means what? So you should not change the character of any place as is present today, and it wants to uphold the status quo, and that is the reason why it is said as a non-retrogression provision is provided in the Places of Worship Act. You cannot change the religious character of any place of worship is the essential principle of the Places of Worship Act. But when this act was being passed, what happened is there were some clear-cut exemptions which have been mentioned in the act. First and foremost, the exemption is the Ram Janmabhoomi dispute or Babri Masjid dispute itself is provided as an exemption to this act, primarily because the case of Ram Janmabhoomi was already ongoing in the courts of India. That is the reason why this particular dispute was exempted from the act. Then along with the act, if there are any settled suits, already there was a dispute and there was a settled suit, then those settled suits are also exempted from the application of Places of Worship Act. Then along with that, the third one is any monument which is included under Ancient Monuments and Archaeological Sites and Remains Act. Ancient Monuments and Archaeological Remains Archaeological Remains Act of 1958. If any site is present, then these are also provided an exemption. So this way some exemptions were provided in the Places of Worship Act of 1991. So which said that, so these are the things which needs to be exempted from the application of Places of Worship Act. Now, the main controversy with respect to the Places of Worship Act as on today is, first and foremost, if you observe, the Places of Worship Act, it has some serious limitations to it. Okay, so one of the most important limitation of the Places of Worship Act is, first and foremost, it restricts judicial review, which is, okay, judicial review, which is a basic structure of Indian Constitution. It is restricted by, okay, the Places of Worship Act, which means that, okay, in order to determine the religious character, in order to change the religious character, no authority has the right, which means that the judiciary's power of reviewing any suit or dispute is restricted by the Places of Worship Act. This is the first serious limitation of this act. Then the second limitation of this act is, it is said that the cutoff date of 15th August of 1947 is very arbitrary. So why did we choose the date 15th August of 1947 is the second major question that has been raised on the Places of Worship Act. And the third major issue with the Places of Worship Act is, okay, in fact, the Places of Worship Act, it in fact tries to pass a legislation with a retrospective effect. And under in the Indian Constitution, no law can be passed with retrospective effect. But this act, it provides for retrospective application of the Places of Worship Act. This is the third serious limitation. Then the fourth serious limitation of this Places of Worship Act is, this act, it restricts the, okay, right to religion is one more thing which is being said about this act, okay, because people's right to religion, right to profess, practice a religion is guaranteed by the fundamental rights under Article 25, and the right of Hindus to worship at these sacred places is being restricted by the act, okay. So this is one more serious limitation of these kind of, or this Places of Worship Act, sir. Now the main issue is, what should be our opinion on this? Okay, what should be our opinion? So we will try to understand and analyze, okay, what is the major or what is a acceptable opinion for this. First and foremost, what we need to understand is the Places of Worship Act, it wants to, in fact, uphold the secular credentials of India. And apart from judicial review, secularism is a basic structure of Indian Constitution. And in order to safeguard the basic structure of the secularism, okay, so we are in fact safeguarding the basic structure of Constitution by upholding the principles of secularism and not going for non-retrogression. So what we are doing is, we are maintaining the communal harmony of India. As the Honorable Supreme Court itself has stated very recently, a month back, under Justice Sanjeev Khanna, okay, and even in the Ayodhya dispute judgment also, the Supreme Court has very clearly stated that the present and future should not be used in order to settle the scores of the past. Okay, so whatever happened in the past, in medieval era or any other time, okay, those things should not be corrected, okay, in the present and future. And if we try to correct the wrongs of the past in the present and future, what will be the outcome is only communal disharmony would be the outcome. Then the second important dimension that we need to understand here is, okay, so one is it protects secularism. The second important principle is, people are saying that, okay, so Places of Worship Act, it restricts the religious freedom of people. But the second important thing that we need to understand is, the right to religion in the Indian Constitution is not absolute, and the right to religion is subject to public order and morality. On these grounds, we can restrict, okay, the right to religion. And what we need to think is, because if the nature of any Places of worship is changed, then automatically it will adversely affect public order. So on the basis of public order also, we should uphold the principles of Places of Worship Act. That is the second thing that we need to talk about. Then the third thing is, definitely there is a need for amendment of the Places of Worship Act, but we need to amend it only in order to strengthen the act, but not to weaken the act, sir. Okay, recently there have been multiple suits filed in the lower courts, okay, particularly on the Gyanvapi mosque case in Mathura, Shah Idaga mosque in the place of Varanasi, then Ajmer Sharif in Ajmer, then Lal Court in Delhi. So this way, or Kawatul Islam Mosque in Delhi, this way suits have been filed on multiple cases. Recently we might have seen, or you people might have seen the case of Sambal Mosque dispute too. So this way numerous suits are being filed in lower courts in order to ascertain the religious character of a particular place. But a month ago, the Indian Supreme Court under Sanjeev Khanna, it has said that from now on, no surveys are permitted in the places of worship in order to determine the religious character of a place. So right now the Supreme Court stand is very clear, and it has given an interme order on the same, and it said that there is no possibility of survey in the places of worship in order to determine their religious character. And the second thing is, no court in India should list the cases or suits filed on under the Places of Worship Act. So if any suit or case is filed, the lower court should not entertain those cases, and they should not list those cases. Bolke, the Supreme Court has very clearly stated, and the interme order, it tries to uphold the principles of places of worship. Okay, so these are the important dimensions that we need to understand in the Places of Worship Act. I hope so that you got some clarity on the Places of Worship Act, and ultimately, okay, we should not use the present and future in order to settle the scores of past. If we try to do that, then it will lead to only compromising of the unity and integrity of India. Keep this in mind. Thank you for your time. Have a good day.